Seabed Authority, the Secretary General of the International Seabed Authority, Mr. Michael Lodge, and the speakers from the International Seabed Authority, Ms. Talatu Akin Dolire, Ms. Mariana Durni, Ms. Gwenel Lagurun, and Mr. Jose Dalo. My name is Ari Afriansyah. I am an associate professor at the Faculty of Law Universitas Indonesia. I'm also the president of the Indonesian Society of International Law Lecturers here in Indonesia. Ladies and gentlemen, I'm so grateful and so happy to open this event, which so much we anticipate in the last few days, because the flyers have been blasted to all over Indonesia, and we are so looking forward for this lecture. Ladies and gentlemen, the seabed for Indonesia is something that we are not quite very familiar in all over Indonesia. However, it is something that's very important in the near future. The resources on the deep sea is something that everybody in this world is trying to be benefiting from. Not only in the deep sea, but also other areas beyond national jurisdiction. Now, every country or every state is trying to make the benefit out of it. The regulation or international regulation regarding the seabed has been adopted and has been quite a while. Then some of us maybe have research and doing something about that. But I think it will be much important if for us, the Indonesian, the academician, the students, and the public in general will be hearing in the first hand of information coming from those practitioners who are actually working on the issue. In this regard, this morning or this evening or wherever time zone you are, the Faculty of Law Universitas Indonesia with Indonesian Society of International Lecturers in collaboration with the Ministry of Foreign Affairs Republic of Indonesia, the Permanent Mission of Republic of Indonesia to the United Nations in New York, and the International Seabed Authority is hosting the virtual lecture on the organization and the work of International Seabed Authority. And without further ado, I would like to invite the Honorable His Excellency, Mr. Ambassador Hari Prabowo, to give the first welcoming remark. Mr. Excellencies, time is yours.
Thank you very much, Pak Ari. Yang kami hormati Bapak Duta Besar Adam Dugio, colleagues from ISA, the Indonesian Foreign Ministry, ISIL, University of Indonesia, and other colleagues. A very good morning to those of you in Indonesia, and a very good evening to you in Jamaica and in New York. It is truly an honor for me to welcome all of you to today's virtual lecture. I wish to first of all extend my deep appreciation to the International Seabed Authority, or ISA, particularly Secretary General His Excellency Michael Lodge and his team at the Secretariat for accepting our proposal to organize today's virtual lecture. I also thank the International Society of International Law Lecturers, or ISIL, and the Faculty of Law of the University of Indonesia for organizing and making this virtual lecture possible. Colleagues, the ISA was established under the UNCLOS, or UN Convention on the Law of the Sea, to organize and control all mineral-related activities in the seabed beyond the limits of national jurisdiction for the benefit of all humankind. The dual mandate of the ISA, namely promoting sustainable development while safeguarding the environment, is of immense significance. To carry out these mandates require rigorous regulatory frameworks and scientific data and research, areas where the ISA has been very instrumental. As the largest archipelago in the world and a nation with vast marine biodiversity, the conservation and sustainable use of marine resources, including in the seabed area beyond national jurisdiction, are among Indonesia's national interests. The active participation in the work of the ISA will enable Indonesia to advocate for and contribute to bringing balance between development and the environment. As future professionals, therefore, today's lecture is very important for all participants as it aims to enhance our knowledge and understanding of the ISA work, especially considering all the prominent speakers we have today, as well as, of course, the presence of Ambassador Adam Tugio, a highly respected legal advisor of Indonesia's foreign ministry. It is therefore my fervent hope that you will make use of the knowledge for the benefit of Indonesia and global communities. And therefore, I encourage all of you to engage actively, ask questions, and reflect on the ISA work for our shared future. Let's embark on this enlightening journey together. And again, I thank all the participants for your hard work and cooperation. Thank you very much, Pak Ari. Over back to you.
Thank you very much, Mr. Ambassador Hari Prabowo, for your welcoming remarks. And I would like to also to say the Honorable Miss Sahadatun Donatirin, the Secretary of the Directorate General of Legal Affairs and International Treaties, the Ministry of Foreign Affairs, Republic of Indonesia, where she will be in the near future or already be the Deputy Chief Mission to the Indonesian representatives to the United Kingdom. Welcome. And now it is my honor to invite the remarks coming from the Secretary General of the International Seabed Authority, His Excellency Mr. Michael Lodge, which will be in a recorded message.
Welcome to this virtual lecture on the work and organization of the International Seabed Authority. I'm very grateful to the Indonesian Society for International Law for organizing this event. It is an initiative that I am delighted to support, and it is a great honor for the Secretariat of the Authority to have been invited to contribute to today's presentations. Indonesia has a long-standing relationship with the Authority and is a staunch advocate for the rule of law in the ocean and for the consistent application of the United Nations Convention on the Law of the Sea. It is therefore our pleasure to be able to support Indonesia by sharing detailed knowledge on the operations and work of the Authority with a view to enhancing the understanding of the academic community about ISA's role and its essential contribution to conservation and sustainable use of the deep seabed and its resources. I'm grateful also to His Excellency Ambassador Nasir, Permanent Representative of Indonesia to the United Nations and to the International Seabed Authority, for his kind words and for his ongoing support to the Authority. Indonesia plays a critical role in the work of the Authority as a member of the Council, especially in terms of contributing to the development of the regulatory framework that will govern future use of the abundant mineral resources of the deep seabed. It is important that this contribution is recognized and that the significance of this work is fully understood. Critical mineral resources are already the subject of much discussion and concern globally. In the future, these resources will assume even greater importance, especially to resource-dependent countries such as Indonesia. And it is essential to have a holistic understanding of all the legal, operational, and scientific issues concerned. I'm sorry that I'm not able to be with you in person for this event and to join the discussion, as I am currently traveling in Africa. But I am pleased to leave you in the hands of the highly competent experts in the Secretariat who will guide you through the proceedings today and answer all your questions. Once again, I congratulate Indonesia on this important initiative, and I look forward to continued collaboration in the future. I wish you a great lecture.
Thank you very much, Mr. Michael Lodge, the Secretary General of the International Seabed Authority. Ladies and gentlemen, excellencies, now we are entering the most anticipated event of this evening or this morning. That is the fictional lectures that will be given by the officers coming from the International Seabed Authority. For your information, the audience that already attended this event are coming from the mostly on academic society, the lecturers, which mostly on focusing on international law, and also the students that might be also focusing on international law. But we also may expect some students that might coming from other faculties, such as the engineering faculties and political and science faculties. Apart from that, we also seen a number of colleagues coming from ministries in Indonesia that have also relevance to the work of the ISA. So let me begin. I will be the moderating of the session, and we will have the privilege and honor to have Mr. Ambassador, Excellencies Adam Mulawaran Tugio, to give general comments after the general lectures. So the first lectures about the mandate, the organization structure, and the pillars of the work of the ISA will be given by Ms. Talatu Akindolire, my apologies, and Ms. Mariana Journey. And for the time efficiency, I would like you to keep your presentation between 10 to 15 minutes. Ms. Talatu and Ms. Mariana, the screen is yours. Thank you.
Thank you so much. Can you hear me okay?
Yes, perfectly.
Okay, good evening, everyone. Excellencies, all protocols duly observed. It is my privilege to be with you all today to be able to share on some of the important work that we do as an organization. So I will be starting. As introduced, my name is Talatu Akindolire. I'm a legal officer at the Office of Legal Affairs, and I will kick off the discussion with sort of like a general broad overview, sort of like laying the foundation to some of the lectures, other lectures that you would be hearing today from my excellent colleagues who are also online. And just in terms of an outline, I found it very interesting that we have a very broad mix of participants. We have from academia and from ministries and from legal and also from other non-legal backgrounds. So I will try as much as possible to make it as engaging and as simplified so that it doesn't get too legalistic for the non-lawyers. So in my presentation, I will start off just by explaining the mandate of the authority. I will talk very briefly about the legal framework, and then lastly, focus on the organizational structure. And then my supervisor and boss online, Mariana, the legal counsel, will handle the pillars of work of the ISA. So let's go. Now, I always like to start these discussions by really explaining to everyone and participants about the very specific work that we do in the International Seabed Authority. The jurisdiction and the reach of the authority is limited to the area. And so the ISA has its mandate just in the area. And I always like to use this little diagram that sort of explains the different zones in the ocean so that we're clear. You know, there's the exclusive economical zone, the continental shelf, the high seas, and then the parts of the seabed that is beyond limits of national jurisdiction. That is where the ISA has jurisdiction. So the ISA has its jurisdiction in the area. And the convention, the United Nations Convention on the Law of the Sea, describes the area in Articles 1.1 as the seabed and ocean floor beyond limits of national jurisdiction. So that is the very specific mandate of the International Seabed Authority. And just as it was mentioned earlier, ISA has two core dual mandates. The first, as was mentioned by the ambassador, is to organize, regulate, and control all mineral-related activities in the international seabed area. And that is for the benefit of mankind as a whole. And in carrying out this mandate of regulation, the ISA also has an obligation to protect the marine environment, to ensure that, you know, there's no harmful effects that will arise from seabed-related activities. So these are actually what I call it, the dual mandate of the International Seabed Authority. Okay, so for the lawyers, actually, it might get a little bit confusing when we say resources. What exactly are we talking about? And Article 133 of UNCLOS makes it a little bit clearer, so that it describes resources as the solid, liquid, and gaseous mineral resources that are found in the area. And remember that I defined the area already in the first slide as the area beyond the seabed, beyond the limits of national jurisdiction. So resources recovered from this specific part of the ocean are referred to as minerals, and that is what ISA regulates, the use of those minerals. So very quickly, just for ideas on, you know, what are the minerals that are really found in the area? I have put a couple of pictures here and just quick summaries of what we're referring to. The first is polymetallic nodules, and they look like pebbles. So you can see from the little pictures over there what they look like. And the important part is the elements that they contain: manganese, copper, nickel, cobalt, and iron. The next mineral that is found in the area is polymetallic sulfides. Now, these look like chimneys, and I think the scientists in the room would be able to sort of appreciate the geological component of sulfides in comparison to nodules. And they also contain heavy concentrations of copper, zinc, silver, and gold. So giving you an idea of why these minerals are very precious and important to economies of the world today. And then the third mineral that is found in the area in commercial quantities at least is cobalt-rich ferromanganese crusts. And of course, we all know how important cobalt is in manufacturing today. So I said there we have polymetallic nodules, polymetallic sulfides, and cobalt-rich ferromanganese crust. And these are the three minerals that are really being regulated by the International Seabed Authority. And the authority has entered into contracts of exploration for these minerals. And these contracts are usually for a 15-year duration with the possibility of a 5-year extension. And my colleague Gwen will talk about this a little bit more in detail in the upcoming presentations. So since we have lawyers in the room, I thought that I would just throw in one quick slide to explain the legal framework under which we operate. And this, again, as I said, will be elaborated further by Gwen and also by Mariana in the forthcoming presentations. So the framework within which we operate as an organization is the United Nations Convention on the Law of the Sea. We also refer to this commonly as our Bible. And the parts specifically that relate to the ISA is the parts 11, annexes 3 and 4. The 1994 implementation agreement is also part of our legal guiding framework. And then also it's important to note that when there is discrepancy between the 1994 agreement and the convention, the 1994 agreement will always prevail, right? And that agreement is really implementing part 11 of the convention. And then we have something that we call commonly the mining code, which composes the sets of rules, regulations, and procedures produced by the authority relating to prospecting, exploration, and exploitation. So let's talk about the structure now that we know what the ISA is all about, the mandate, what we really focus on in terms of our day-to-day work as an organization. So having dealt with that, now let me talk a little bit about the structure of how ISA operates. This is just a quick infographic. I hope it's helpful to describe the respective organs of the International Seabed Authority. We have the Assembly, the Council, the Enterprise, the Secretariat. Then there's the Legal and Technical Commission and the Economic Planning Commission, which fall under the Council. And I'll go a little bit into details in my subsequent slide on those. So let's quickly start with the Assembly, right? So the Assembly is the supreme organ of the authority, and it comprises 168 members. The functions of the Assembly are listed in the convention, but as just a quick summary, I've listed a few of the core functions and role and responsibility of the Assembly. And generally, the Assembly meets once in a year in Kingston, Jamaica, usually in July. We also have the Council. The Council is comprised of 36 members. Remember, I said the Assembly comprised of all the members of the authority, 168. And then the Council comprises 36 members. It's the executive organ of the authority, and it has specific functions in Article 162 of the convention. And some of the core functions are to establish specific policies, supervise, and also, like I said, there are subsidiary bodies that the Council manages, such as the Legal and Technical Commission. We also have the Enterprise. The Enterprise is envisaged as that body that would facilitate the participation of developing states in carrying out activities in the area. Now, the Enterprise is not yet independently functioning. It's still functioning currently as part of the Secretariat, because in the 28th session of the authority last year, the Council approved the appointment of an interim Director General of the Enterprise. So the interim Director General is currently still within the Secretariat. And this, talking about the Secretariat now, this is a quick infographic that shows you the structure of how the Secretariat functions. The Secretariat is also an organ of the authority, and it's headed by the Secretary General. The respective offices are there, and then we have the Enterprise, which is currently within the Secretariat. The subsidiary organs of the Council are the Legal and Technical Commission and the Economic Planning Commission, and then the Finance Committee rests under the Assembly. So I will just wrap up now with another infographic the same infographic that I showed in the beginning, that sort of shows you the structure of how the International Seabed Authority works. And with that, I don't want to take up too much time. I would look forward to the session where we can have some engagements and answer some questions that may be in the minds of the participants. Thank you very much. Over to you, Mariana.
Thanks, Talatu. I'm going to share also the presentation. And I hope you can see it now.
Yes, we can see you.
Excellent. So, well, good afternoon, good morning to all there in Indonesia, New York, Jamaica, or maybe another places. As said, my name is Mariana Journey. I'm the legal counsel of the International Seabed Authority, and I'm very, very pleased to be here today joining this virtual lecture. And I'm thank you to all organizers, because this kind of opportunities for us is very, very valuable and precious to share the work that we do in the ASA with academics, with students, with governmental officials, and general public in general. So it's my pleasure to actually complement the presentation that Talatu just made, because I'm going to talk about the pillars of work of the International Seabed Authority. And when I refer to the pillars of work, I'm just addressing in a more comprehensive manner the mandate that was conferred to the authority by the UNCLOS and the 1994 agreement. As said by the ambassador, there's a lot of academics of international law here and students, so you must know that as an international organization, ISA must act within the scope of the legal competence that were given, and also are governed by rules and principles. So the mandate of the authority is so unique that cannot be understood if we don't also have in mind at all times the principles that govern the area as established in the Part 11 of UNCLOS. So that's why I will start briefly recalling also those principles. So those pillars of work actually refer to both things, the principles of governing the area and the mandate, the specific mandate of the authority. Now, if we recall the principles, we will start with this very, very essential part, that is the, we will recall that definition of the area that was given by Talatu and the type of mineral resources that could be found in there. Under UNCLOS, you will recall that the area and its mineral resources are the common heritage of mankind. This is under Article 136. So this principle is so fundamental to UNCLOS that is protected for any amendment, and also it is forbidden for all state parties to become party to any other agreement that could be in derogation thereof. So this common heritage status actually was established even before the UNCLOS negotiation, or the succeed of UNCLOS negotiation 3 and what became the UNCLOS in 1982 through the 1973 Declaration of Principles by the UN General Assembly. So it is a very, very deep principle and dear principle for the international community. This principle ensures that interests of all humankind are safeguarded through a special legal regime that recognizes the importance of preserving the marine environment and developing the natural resources equitable. So this will need to be done in a manner that respects the interest of individual states, while acknowledging at the same time that these interests can only be safeguarded within the framework of a stable international regime of cooperation between states. So there's some key legal consequences that these principles include. So the first one is non-approvability. This is very important. So no state or entity, a natural juridical person can claim or exercise sovereignty or sovereignty rights. Those that are lawyers will understand this difference, we will go there, of any part of the area or its resources. Mankind's right. All rights in the resources are vested in mankind as a whole and should be exercised through the International Seabed Authority. So there's one beneficiary, that is mankind, and one way to exercise, through the authority. So the paragraph 2, this is in Article 137, paragraph 2 prohibits the alienation of the resources of the seabed in any other way than in accordance to the provision of the convention, and also established that no claim, acquisition, of exercise of right respect with the minerals of the recovers from the area could be made by any state, not only just state parties, but any state of any natural or juridical person could be recognized other than by Part 11. Benefit of mankind. What this means? That activities in the area shall carry out but the benefit of mankind as a whole. This means that irrespective of the geographical location of the state, whether they're coastal or landlocked, and taking, and this is very important for Indonesia, for example, taking into particular consideration the interests or needs of developing states and of people who have not yet attained full independence or other self-governing status. But let's keep in mind this part also of the interests and needs of the developing state, because we will see, not now in detail, but this spirit of having in mind particular interests of some states, it's very highlighted and taken into account through the whole provisions on Part 11 and 1994 agreement and the spirit of what is this regime. So to give effect to this aspiration, the authority is tasked with the development of mechanism to provide for the equitable sharing of a non-discriminatory basis of financial and economic benefits derived from the deep sea mining. And the last but not least important principle is that the area shall be open exclusively for peaceful purposes and for all states, whether coastal or landlocked. So this is also very important. So these are the principles that are at the core of the mandate of the authority. So let's recall what are the mandates. Ambassador Antalatu referred to the dual mandate because this is what is the most obvious mandate: protect the marine, allow to the activities on the area, but at the same time protecting the marine environment. But actually, when we see what are all the powers conferred to the authority according to UNCLOS and according to the 1994 agreement, and we see the whole broad scope of competences, implied and explicit competences that it has, we can find actually 4 main pillars of these powers or competences that ISA has. One is manage, protect, promote, and share. What does this mean? Manage in terms of exploration of resources, protect, obviously, the marine environment, promote marine scientific research, and share that part of the monetary and non-monetary benefits. All these mandates and purposes are complementary, cannot be achieved in an isolated way. And this is sometimes what it is in the core of the debates that we see very frequently and very crispy sometimes. They're not excluding objectives. On the contrary, the whole purpose of having a special regime for the area was to prevent that exploration and exploitation activities could be undertaken without proper rules, which secure the protection of the marine environment. So there's no way to have activities in the area without the protection of the marine environment. They're not contradictory. There's no one or another. You don't have to choose. Must be done with the two of us. And in the same vein, exploration, exploitation, and protection of the marine environment need knowledge of the deep sea through marine scientific research. And the purpose of the whole system, of course, it has been established for the benefit of us all, is to distribute the benefits of these activities, the sharing of the benefits. So this sharing of the benefits, and we will repeat this, will be both monetary and not monetary. So this is a whole system. This is why we talk about the 4 pillars. And it's a dual mandate, but 4 pillars that encompasses the whole system of ISA and our mandate. So this is what makes ESA so particular, because it's the only example of a global common that is regulated through a consensus-based international organization for the common benefit. So let's refer very, very briefly, of course, to these 4 pillars. First, we have this management of exploration and exploitation activities. The ISS system is often called the parallel system because it was foreseen as allowing both the authority through the enterprise that Talatu referred to and state and entities sponsored by them for state and entities to conduct mining activities. So both this part of the authority and states and entities. And the 1994 agreement encouraged these joint ventures between the enterprise and other operator. And an important task of the authority, as we will see with WEN, is to adopt these rules and regulations and procedures for deep sea mining activity, what is called the mining code. What is worth keeping in mind is that as today, this is the only example, I said, of Global Common regulated through an international organization. Second, that no activities can be permitted unless a contract is signed with ISA and receive the support of a sponsor state. And the support of a sponsor state is required for a matter of responsibility, liability.
Apologies, Mariana. You have still 2 more minutes?
2 more minutes, okay. So the entire system is regulation is based on consensus, and there are not other activity that international where the international community has a chance to develop regulation before it starts. There we have a map, an infographic, where the exploration activities and contracts of exploration activities are already signed with 22 different states or contractors obviously supported by states. Let's see that also ISA has a role in the protection of the marine environment beyond the national jurisdiction. How it does this? Obviously mainly through the adoption of rules, but also through these other tools like environmental impact assessment, regional environment plans, mandatory baseline data collection, monitoring. Another way to end the precatory approach, of course, is in the middle of this. ISA in marine scientific research, Jose will talk about this, so I will leave it there, but is the third pillar of this important work that we do in ISA. And the other one is benefit sharing. And in this part, it's very important to notice, and I will leave it here, that as ISA has to develop a system to share and to report the benefit that will arrive from exploitation when this commences, because it hasn't commenced yet, as is include non-benefit benefits that we can see there, one of them, a list of them, like training, capacity building, environmental protection, increased scientific knowledge, expansion of world mineral resources, and preferential access rights for developing countries. Those are already being shared with the international community. So all that part that is non-benefitary benefits are already taking place, and there's a lot more to develop. So the system of monetary benefits is being developed by the organs, appropriate organs that are with competences to do so. There's the different systems that are being discussed. But as a conclusion, again, this is the unique case of an organization that is trusted with a common goal. And this is not to allow that this rich area that belongs to all suffer with the tragedy of the commons, so just leave free exploitation without any rules, and also to make this contribution to the scientific research, knowledge, and the strengthening of the rule of law in the ocean. So thank you very much, and I'm sorry for, maybe we can go deeper in the questions. Thank you so much.
Thank you very much, Ms. Talatu Akindolire and Ms. Mariana Durni. as the legal officers of the International Seabed Authority. Next, we will have Ms. Gwenel Gurun, also legal officers from the ISA, that she will be talking about the role of the ISA in regulating the activities of states in the deep sea. The screen is yours, Gwen.
Thank you very much, Professor Afriancia. Good morning, everybody, excellencies, professors, and members of the academic world, students. It's really an honor for me to be provided with this opportunity to describe the role of the International Seabed Authority in regulating the activities of states in the international seabed area. Next slide, please, Professor. Thank you very much. So as Mariana and Talatu have already touched upon, the authority not only is a unique organization established by the 1982 convention, but it's an organization which has also received very important regulatory powers to elaborate on the legal framework which derives from the convention and from the agreement. Let's please move to the next slide. This has already been shown to you, but it's, I think, important to recall the fundamental architecture here. When we are talking about the regulatory powers of the authority, these are what we call in law the secondary legislation, meaning these regulations, rules, and procedures of the authority, which are called the mining code, need to be consistent with the primary source of law, which is found in the United Nations Convention on the Law of the Sea, and more particularly its Part 11 and two very important annexes, 3 and 4, and also for legislative aspect in Resolution 2. As you know, the convention has been implemented for its Part 11 in 1984. And of course, the system of law needs to be consistent with other rules of international law and decisions of courts and tribunals. Next slide, please, Professor. So we have heard about the mining code. What does this mean? This means a comprehensive set of rules, regulations, and procedures which are developed by the authority to regulate activities in the area. Activities mean exploration and exploitation. They cover three scopes of mineral resources: the polymetallic nodules, the sulfides, the crusts, but only for exploration. And right now, the authority is developing the regulations on exploitation. So the mining code refers to those rules, regulations, and procedures, as well as the recommendations and guidelines which are issued by the Legal and Technical Commission. Next slide, please, Professor. So I'm going to devote part of the presentation on the exploration regulations, and then move to the phase we are now, the elaboration of the exploitation regulations. So we are really at the crossroads, at the transition between regulating exploration with contracts already in place and moving to exploitation. But I insist, we have not yet adopted those regulations on exploitation, and there is not yet a contract for exploitation. Next slide, please, Professor. So, to describe the role of the authority in regulating activities in the area, the aim of my presentation is to attempt to respond to three questions. How does the authority exercise the regulatory powers? What has been regulated so far? And you already know the answer for that. And at which stage we are now. So these slides give an overview of where we are in terms of the regulations which have already been adopted, which are in place, and which have enabled the authority to issue contracts, as Mariana has mentioned. Contracts are necessary for activities to be conducted in the area, since this is a fundamental principle of the common heritage of mankind. There is no activity which can be conducted without a contract being issued by the authority. And for that, we need to have the regulations in place. Next slide, please, Professor. So for everybody who is interested in going into more detail on the regulations and the recommendations which have been adopted so far by the authority, these are grouped into this publication, which can be found on the website of the authority. And this is really our regular daily reference in the work we are doing in the Secretariat with my colleagues. Next slide, please, Professor. So we have talked about prospecting and exploration, and I just wanted to clearly maybe describe what they mean and what is the legal regime which is associated with those terms. I've mentioned prospecting. We have already had 2 prospectors in the life of the authority. Prospectors actually notify their intent to prospect. This means to search for mineral deposits, but this is without any exclusive rights. And this does not need a contract. Exploration, in contrast, means searching for potential mineral deposits with exclusive rights under a contract. And the contract is granted at the end of an application process, which involves the Legal and Technical Commission and the Council, which Talatu has presented. Next slide, please, Professor. The regulations, as I say, are from time to time complemented by detailed recommendations, which the Commission, the technical and legal expert body of the authority, issued from time to time to guide contractors in their activities, so they can relate to training programs, they can relate to the environmental impact assessment of activities conducted by the contractor. They are very detailed. And they are regularly revised to keep them abreast with scientific and technical development. Next slide, please, Professor. So what I've described so far relates to the regulations which are binding, which are in force. Now, the second part of the presentation will deal with draft regulations on exploitation. This underlines the current and priority regulatory activity of the authority. We are now engaged for several years in the Council with the negotiations of regulations on exploitation of mineral resources. Next slide, please, Professor. Thank you very much. This slide shows actually the first, the draft regulations on exploitation of mineral resources in the area, which you can see on the slide, which were issued by the Legal and Technical Commission and which were presented to the Council in 2019. These draft regulations consist of a very comprehensive set of provisions which are grouped into 13 parts, 10 annexes, 4 appendices, and 1 schedule on definition of terms. Exploitation regulations will be supplemented with standards and guidelines. And in February of this year, the President of the Council has released a consolidated text, which includes progress made by the Council through proposals being made through discussion during session and intersessionally, which have modified the draft regulations which the Commission presented to the Council in 2019. So the consolidated text is made of 225 pages, which has modified the set of draft regulations proposed by the Commission. But this is still a draft text, which is still under negotiation to reach consensus, because an important aspect of the work of the authority is that the regulations are adopted by consensus. Next slide, please, Professor. This very important work, which is at the core of the work of the Council and has been for several years now, has necessitated, forgive me, the adoption of roadmaps. The roadmaps describe the organization of the work of the Council. Last year, for example, the session of Council, meaning the time, the number of meetings of Council, has made it necessary to have 3 parts. And most of the parts of the session were devoted to the negotiation of the draft regulations. The work is conducted either in plenary or in informal settings, in informal working groups. And already this is the 3rd roadmap, which we will see in the next slide, Professor, if you could. Voila, thank you very much. This snap shows an extract of the current roadmap, which describes very concretely the number of days the various organs are meeting. This is about the following meeting, which will come in July. And you can see that the priority of the 2-week meeting of the Council is to continue the consideration of the consolidated text.
Sorry, Gwen, 2 more minutes.
Thank you very much, Professor. Could you please show the next slide, please? Alors, I will go very briefly into the conceptual topics, which are still at the core of negotiations. Very important element of the regulations are the financial aspects, the financial terms of a contract. Here, the discussion is about which model for the calculation of royalty, meaning the percentage which will be paid by the contractors. And next slide, please, Professor. Another very important set of conceptual topics which relate to another key component of the regulations relate to environmental aspects. Here are listed the topics which are still under close discussion in working groups most of the time. You can see the broad scope of questions from environmental impact assessment to test mining to regional environmental management plans, compensation fund in case of damage not covered by liability of contractors, and the definition of the underwater cultural heritage in the area. Next slide, please, Professor. Another aspect, very important one as well, which is still under discussion, is how to define, how to devise an inspection mechanism. There are 3 principal approaches: to use what the Legal and Technical Commission, or to create a specific committee, or to have an independent inspectorate, but whatever model or hybrid model is found appropriate, it will be needed to define the relationship with the existing commission if, for example, the commission is not assigned with those inspection functions. Next slide, please, Professor. As a part of the regulations which still require some discussions relate to institutional matters, and in particular to the effective control exercised by a sponsoring state over the contractor, the entity which is sponsored. Next slide, please, Professor. This is giving you a bit more details of where to find those important questions which are discussed by that group. Next slide, please, Professor. I've said, and I will go very briefly because we're running out of time here, but the regulations have to be supplemented by standards and guidelines. There are 3 phases to develop them. The first phase refers to the standards and guidelines that need to be in place before the time of adoption of the regulations. These have been already prepared by the Commission and presented to the Council. They are listed here, and the document is referred on the slide. Next slide, please, Professor. This shows how the standards and guidelines were developed for phase 1. You can see that this involved a stakeholder consultation, the Commission, and then the Council. Next slide is to thank you very much and to close the presentation and to wait for the session on questions and answers. I thank you very much, Professor, for your assistance and the audience for your kind attention. Thank you.
Thank you very much, Ms. Gwen Legurun, legal officers, that she talks about the role of the ISA in regulating the activities of states in the deep sea. What a very comprehensive presentation. I think we all have very much information, and I hope the participant will not be overwhelmed with this information. Thank you very much, Gwen. And last but not least, we have Mr. Jose Dallo. He is the director of the Office of the Environmental Management and Mineral Resources of the ISA. He will talk about the contribution of the ISA in deep sea science and attainment of the SDG in 2030. Mr. Jose Dallo, the screen is yours.
Well, thank you very much and for this opportunity. I try to complement what colleagues have been saying and try to bring the 2 additional flavors to this dish, which is the science, the work on science, and the impact on the Sustainable Development Goals. If you, Professor, could go to the first slide. Could you please go to the first slide, please? You saw this slide before. I think Mariana has shared with you. I want to also share with you, but from a different perspective, and basically tell you why I did join ISA. And I did join ISA because it's a multilateralism that is working. These days, we see so many global tensions and so many global problems. And that was why I joined. When I joined, I saw these different 4 mandates. And somehow you have to accompany all of them at the same time, which is not easy. You have to manage, but at the same time protect, but to make sure that everyone gets a share. So definitely I say is the place to have this policy science interface. And you probably will hear that in many multilateral fora, and also I think in national fora, where we want the decisions to be informed by the best available knowledge. And this available knowledge sometimes is not completely clear, so pose us with dilemmas. And that's where the political decisions, that's where our representatives, in this case, member states, make a decision in terms of which kind of regulations which kind of sharing, benefit sharing, which kind of programs they want to support. Next slide, please. Again, you saw this one too, but I want to highlight the three different types of work that ISA is managing. One is the prospection that anyone can do. Then it's the exploration, when contractors go and see what is down there, particularly in terms of mineral resources, and they use science for that. And then the next phase that has not started yet is exploitation. So through exploration, we're learning a lot. It's producing a lot of science, a lot of knowledge, a lot of data, and that will help us establish the baseline and the critical elements for the exploitations. Many times we think that we don't know much about the deep ocean, but the first exploration that happened was in 1872. It was the HMS Challenger when they discovered the nodules. We have now, for example, in our database, I encourage you to all to visit, called Deep Data, more than 10 gigabytes of data. And we have many technical studies that you can find there too. For example, the latest ones that we did was on the overlapping between mining activities in the future and deep fisheries, in terms of trying to bring together not only the science about mining, but also the science of the environment, the science of the fisheries, and the science of all the uses of the ocean. And as you know, more and more we hear the word blue economy and the opportunities that
Jose? I think Mr. Jose is out from the Jose. Okay, there you go. Mr. Jose Dalo, are you there?
Yeah, I think I disconnect.
Okay.
It's not working very well. The
Yes,
system.
now we can hear you. Yes, now we can hear you. Maybe you can turn off your camera so the connection will be better. Thank you.
Yeah, I don't see the slide. Okay, if you can go to the next slide, Professor, please. Slide number 4. In terms of protection of the marine environment, maybe just allow me to give you some examples of the things that we do. It has been mentioned that we do environmental impact assessment. So when a contractor wants to test some technology, depending on what they're gonna do, they have to prepare that, and is reviewed by the Legal and Technical Commission, which is comprised of lawyers, scientists, geologists, oceanographers, biologists, and they ensure that is well done. We are now, for example, defining environmental thresholds on chemicals or light and noise on the plume that might be generated by the mining activities to set, maximum levels that can be tolerated by the different ecosystems. We also have monitoring plans, and all contractors are mandated to have a monitoring plan of what they're doing. We also do something called REMS, which is basically the planning of the different areas. It's like on land. You have maybe a nucleus area that you're not going to touch. Thin ecosystems or specific weak ecosystem are preserved. You have buffer zones, and they define in which areas the mining could happen. Next slide, please. And as we have said, this is underpinned by marine scientific research is something all countries agree, all members of ISA, all delegations, in addition to moving together, all of them agree on the need for science. Next slide, please. So what we have done at ISA is a deep sea research agenda. This was discussed by and approved by all member states. And this agenda for research in the deep sea is part of the efforts that the whole UN system is doing under the decade for ocean science that UNESCO is coordinating. So what this, the importance of this document is that it was agreed by all member states, is the kind of science we want and we need for the ocean that we want. But SDG 14, or the science on the ocean, is the less invested SDG. And we recently were in a meeting in Barcelona organized by UNESCO, trying to call for more action on this domain. So there's definitely a need to invest more and to have more capacities on that. It's not only the money from many countries, it's also not easy to have the labs, to have the teaching programs, the research that can carry out these very specific and niche studies of the deep sea. Next slide, please. So the MSR action plan, the program that countries agree, has 6 priorities. One is advancing on the knowledge of the deep sea. And that, for example, is all the work that we do on new topics that can be discussed on and affect the deep sea. For example, lately we have been assessing how the deep sea could help us understand better how plastic pollution is affecting the ocean. Number 2, we want to know more about the biodiversity down there. For example, we recently launched a call for proposals for scientists to describe new species. And probably in a year, we'll be describing more than 110 species. Number 3 is technology, and of course, as an enabler for all the work on science. We recently, for example, had a workshop in Portugal to understand the capacities of the sensors, those sensors that can help us identify new animals, that can help us monitor the mining activities, that can help us understand better what's happening down there. Number 4 is understanding the environmental impacts. And here, where we work most is to understand cumulative impacts, because you have maybe different impacts. Maybe you have the plume generated by the mining, but you have also climate change. And maybe you have the acidification of the ocean, to understand how they come and play together and how we can lower their impact. Number 5 is data. And as I mentioned before, we have a repository of data called Deep Data. All the environmental data is publicly available, and then anyone can go there, download the data, or try to better understand the richness of the deep ocean. And number 6 is capacity development, and making sure that the field is playing for all countries to benefit from science in the deep sea. And we carry out training of different level, internships in our in ISA. Sometimes, for example, training opportunities, and maybe some of you would like to apply with our contractors to go on the sea and collaborate with other scientists or legal issues. So we have an important program on making sure that developing countries can also benefit from the deep sea. Next slide, please. Next slide, please, Professor.
Yes. Wait a second.
Yes. Yeah. So basically, I just wanted to show that for this generation of knowledge and science, we rely on our contractors, and you have there a snapshot of the huge investment they have done lately on environmental studies, on the number of cruises they have carried out only for polymetallic nodules. Next slide, please. And we all this for 2 reasons. One is for the protection of the environment, and the other one is for the sustainable use of the ocean. And we carry out an independent study on how do we benefit the different SDGs through the work of ISA. which maybe is not intuitive, but for example, let me give you some examples. On SDG number 5, gender equality, we have a program when we find mentors for mentees in developing countries for women who are studying science and need some help, for example, to find a career path in normally a man-dominated domain of science. Of course, we work on environmental issues, as I mentioned before, on energy. The minerals that will come from the deep sea will be critical for the energy transition to renewables, on technology and blue economy, as I was mentioning before. So you can find this study online in our website, and we found that we contribute to 12 of the 17 SDGs. Next slide, please. And this is the last one. Just wanted to highlight that we don't do this alone. And as you can see, we have a lot of partners there. We have bilateral agreements with countries like Indonesia, and we work with them. Sometimes it's with other international organizations, with the CBD, with UN, outside the UN, inside the UN, regional, global. We sometimes as well have a lot of work with different processes and the definition of different processes. Lately, for example, the agreement called BBNJ, which is trying to protect the biodiversity in the ocean and the deep sea. We have joint, training centers, one in China. We just recently opened one in Cairo for Africa. So we're trying to expand that network that help us both in the science and also on the delivery of the SDGs. And I think the last slide is the last one. Just a big thank you to all of you for listening. Apologies for the technical hiccups. Professor, over to you.
Thank you very much, Mr. Jose Dalo, Director of the Office of Environmental Management and Mineral Resources, which given us different perspectives, not from the legal issue and information, but also from the environmental and science. And of course, I can see now a number of questions that are being raised by the participants. But before that, we would like to listen to the general comments or maybe another insights from our own ambassador, His Excellency Adam Mulawarman Tugio, which I'm also proudly to say that Mr. Ambassador is also the alumni of the Faculty of Law Universitas Indonesia. It is great to having you, Mr. Ambassador. Time is yours. The screen is yours. Thank you very much.
Well, thank you. Thank you very much, Professor Ari. And also to all, let me greet all panelists and expressing my appreciations to all the panelists for sharing their thought on the works of the international seabed authorities. And I certainly would like also to use this opportunity to welcome the initiative. I think this is good initiative, which I hope would once again revive or renew the interest of the international law students and faculty members on the law of the sea, especially noting the latest development. And looking at the presentations by all the panelists, it gave me a sense of deja vu attending the meetings of the ISBA, which the conference overseeing the Caribbean seas, which such a lovely place. And I think a part of that, all the panelists already mentioned about the works of the International Seabed Authority. Let me make a reference to Indonesia, because I think this is something that need to be underscored and highlight how important of the International Seabed Authority, the ISA, and also the roles of Indonesia, not only in the past but also in the future. And I think Professor Ari, the moderator, is very kindly when he mentions about the unfamiliarities of the nations today about the important works of these institutions, and also the potential benefit that developing countries like Indonesia can reap the benefits of the activities of the International Seabed Authority. I think there was also some criticism in the past, but I think to some extent also still stands today, whereby in Indonesia some raised the lack of interest, where the moderators once again is very kindly to refer to the unfamiliarity. I think we can look at on a different aspect, but I think because of the fact that we are being an archipelagic countries, we are surrounded by 10 neighboring countries who share a border, most of them sharing some maritime borders. So I think we are too busy with trying to resolve all the maritime border area, and then give less focus on the important work of the potential benefit that we can get from the area beyond national jurisdictions, which under the authority of the International Seabed Authority. And I think if I may give some comment on that, I think there are several challenges that we are facing in Indonesia. One, certainly on the human resources and technological development, because when we had the presentations by all the panelists, we learned how very technical the issues of the explorations, prospecting, explorations of these of the seabed, the area, what we call it, the area, is how complex the technologies are required for states to be able to dispatch or send their team, to give some idea on the prospect of the minerals that's already in the area. And I think the second aspect also relates with the funding allocation fund. It is very costly. I think Jose already mentions the cost for the trying to make a baseline for the environmental protection is very costly, more than 100 million. And I recall that one study by UNESCO. UNESCO reported on 2017 already indicate that at least for this explorations, prospecting exploration, it costs about 10 to 15,000 per day. So imagine that the durations of the for one project for these purposes, it may cost around 10 to 12 billion for a single project. So very, very costly, huge amount of resources that need to be poured for states to be able to to do this prospecting and exploration. That's why nowadays we see that some countries also joining with different countries in trying to get the opportunity to send and get a contract or with the international seabed authorities together, because once again this is so costly. But I'm glad that nowadays there is a lot of renewed interest in Indonesia and also the global. I think one of the very important factors, I think the switch toward green energy, whereby the countries nowadays trying to to switch into developing a green energy. And if you look at once again the mineral that can be found in the area, we see that's all actually the essential ingredient or essentials mineral element for building the electric vehicles or the battery. Mangan, cobalt, nickel, both all are very important for building electric vehicles and all greening energy as a whole. So I think there's a lot of renewed interest in this regard, not only in Indonesia, but also countries around the globe on the prospect of getting some mineral from the area. But I think for the countries like Indonesia, as the exporter of the commodities, some of the commodities like nickel and cobalt, I think one of the aspects that also relate with the conversations or discussions in the International Seabed Authority, and how then it could, the benefit sharings or in the futures can also take into account the the impact to the exporting countries, the compensations, or what kind of the arrangements that need to be made in the future for the exporting countries who certainly will be affected by these exploitations because the raw materials may be go down, because of the abundant availabilities of these resources. Now, the second growing interest from the Indonesian side, I think it relates with the fact to the establishments of the National Institution for Research and Innovations, or BRIN, or BRIN in Indonesia. And I'm glad to make a reference to the BRINs because to this institute, because at least we have one expert from Indonesia, Dr. Angga Dwi Novianto, who also members of the Intersessional Expert Group of International Seabed Authority. So I think this is a good indications now, renewed interest from the Indonesian side to be more active in discussions of the International Seabed Authority. And in fact, the Indonesian ambassadors in New York also attended a meeting of ISBA, I think 2 years ago. I think this is a good indication because in the past, it's very rare that the meeting in ISBA attended by such a high-level ambassador. So I think that's another indication on how we see the importance of the Seabed Authority nowadays. And lastly, also we just issued, the government of Indonesia just issued the Presidential Regulations number 8/2023, December this year, which underscores the importance of the Indonesians' roles and engagement in the International Seabed Authority. So this laws, together with the several laws on the ocean affairs, which was launched in 2014, 2020, and I think those will provide a good foundations again for the Indonesians to be more active in the works of International Seabed Authority. And for the Seabed Authority and also the international community, I think this year also is very important because the second review of the International Seabed Authority, if I'm not mistaken, will take place on August this year. So 30 years after the establishment of International Seabed Authority, certainly it's good momentum to reflect what already been done by the institutions, and how the International Seabed Authority can make more contributions in the future. Because I think the challenges for this relate also with the fact that in the next 2 years, we hope that the international community could adopt the draft or finalizing the draft exploitations regulations by 2025. So the momentum is there, meaning that once the draft already been adopted, then it will start the explorations phase. And I think that will be that will give additional a burden for the International Seabed Authority in the future. Seabed Authority works in the future, and the momentum is also related with the fact that the conventions of biodiversity beyond national jurisdictions also already been adopted, or was adopted, if I'm mistaken, last year. So I think those new developments can provide a momentum for the International Seabed Authority to once again to look at the increased workload of the Secretariat, but at the same time also to devise an appropriate regimes of sharing the benefit. And also, with the growing interest on deep seabed mining, then the Seabed Authority can, charting the way forward in trying to balance the need to promote the economic benefit of exploitations of the area, but at the same time also protecting the marine environment beyond national jurisdiction. So I stopped my general observations with that. Then once again, let me congratulate the organizer for this initiative, and also to all the panelists who already shared their thought and views on the work of International of Seabed Authority. Thank you very much.
Thank you very much, Mr. Ambassador, His Excellency Adam Mantugio, for your very rich insight, as you have been there by yourself to do the issue that maybe a very few of Indonesian gets that opportunity. Thank you very much for sharing with us, Mr. Ambassador. And now we are get into the session of the discussion. I have already a number of written questions in the chat box, and I would like to invite for those who want to give the question directly, please raise your hand. But first, I would like to read two questions and then one live question from Miss Aurora Meliala. So the first question is coming from Rio. He asked, when will the draft exploitation regulation be finalized? And once it is final, does it mean that the mining could be immediately conducted by the countries? Yeah, maybe this could be addressed to Ms. Taratu or Ms. Mariana. And the second question coming from Eke Celestine Sigozi, yeah. He asked to Ms. Gwen, how does the ISA conduct its oversight function towards ensuring that all the activities done in the area are in compliance with the ISA rules? And there's another question from him. He said that my other question is about contracts with the ISA to conduct activities in the area, since the enterprise is not currently active. For these contractors, are there prerequisites for qualification, or can anyone or company apply? And what are the usual contract conditions apart from states being liable? That's the two questions from the written in the box. And I would like to invite Ms. Aurora to pose your question.
Yeah, first of all, let me deliver my gratitude firstly for Pak Ari, who already initiated such of wonderful Zoom meeting, and then also for all the speakers that has give us a very such a wonderful informations. My questions is priorly Mrs. Darni have explained that there is 15 years contract for a Seabed project, and there are parties such as enterprises and sponsor state who has effective control on such project. And later, Mrs. Guanel has also comprehensively explained in detail about explorations regulations, and also we might understand that from Bapak Diplomat previously, that explorations and maybe exploitations, particularly for offshore mining, require very high expenses, especially in technology. And not all countries have the same financial capacity to invest or to become sponsor state in this matter. So my very questions, how exactly ISA ensure the justified global share in the monetary perspective? How do you exactly implement the idea of justifiable shared benefit? Because we already understand that on the previous presentations that there is indeed non-monetary benefits. But what I would like to explore more is how about this monetary shared benefit that is regulated by ISA, especially for developing countries located nearby and might experience an environmental impact on the marine yet not having maybe financial direct contributions, or maybe less financial contributions in the explorations, or maybe in the scientific research? That's my first questions. And then my second questions, it might be for Mrs. Talatu, because it's in regards of legal framework. We do understand that there can be disagreement over the interpretations and applications of international law and agreements governing the use of protections of seabed, such as UNCLOS. Conflict may arise over such issues like definitions of EEZ, exclusive economic zone, freedom of navigations, and the rights of landlocked states. So my very questions, how ISA manage this legal problem, especially when it comes to the definitions and the conflict between each countries. Thank you.
Okay. Thank you very much, Ms. Aurora. Now I would like to give the screen to Ms. Akindolori and Ms. Durni to give your answer and comments. Thank you.
All right, thank you. Mariana, should I go first, or do you want to?
Go first, and I will address the sharing of benefits if you like.
Okay. Yeah, so I can just thank you so much for those questions. Very interesting and challenging questions. I was taking note of a few. I probably will start with the last question from Aurora, and it was to do with the interpretation of the use of the definitions as to what is EEZ versus what is the area, and how, you know, ISA manages the definition of the maritime border. So as an organization, we do not make any delimitation of borders. What we do is that we ask states to submit charts when they have their, you know, their extended continental shelves, or to tell us the boundaries within their own coastlines. And then the area beyond that is what belongs to the ISA. So in essence, we do not do any delimitation of our own. It's really the areas beyond what has been delimited by states that then falls into the area. And that is the jurisdiction that we have as an organization. And there's a provision in UNCLOS, I don't remember the specific number of that provision now, that requires states to submit geographical charts to the Secretary General for that purpose. I think Mariana will handle the sharing of monetary benefits, which Aurora asked, so I would leave her with that. And then there was a question from Rio, and maybe Gwen can also provide some directions because it was on the exploitation regulations, but I can quickly say, I think it's the question on the chat, which says, when will the draft exploitation regulations be finalized? And once it is final, does it mean that mining could be immediately conducted by countries? So there is currently no deadline as to when the exploitation regulations are to be finalized. It's being negotiated in the council, and then the members of the council have a roadmap to review and, you know, progress the work. But in terms of having a deadline, the Secretariat doesn't have a deadline, and the member states do not currently have a deadline. And also, when the text of the regulations are approved, then it would obviously be agreed when mining officially can start, and whether there would be a ramp-up period or whether it would be, you know, a timeline therein. So that is also part of the matters that are being negotiated. So the answer to that question is there is no current deadline for the finalization of the draft regulations. So I'll pass it over to Mariana on the question about monetary shared benefits. Thank you.
Thank you, Talato. Yes, well, the sharing of the benefits obviously is a very, very important topic, and it's not an easy one. Let me take this off. Okay, and we have several aspects to consider here. First is that in the regard with the benefit of monetary aspect, there's little guidance in the UNCLOS and in the 1994 agreement. So I guess that I think that your question, I heard it I think that included monetary, included exploration, although what is expected is that the monetary sharing of benefit will come with the exploitation phase, more likely, not with the exploration phase. The exploration phase could be demonstrated this kind of monetary sharing, but in a more indirect way, because it's not a direct way of distribute the revenues, because they're not revenues as such. So this part of the monetary benefit will come with the exploitation phase, probably with the royalties that will be paid to the authority. The modalities is being discussed. So that's the first clarification that is need to be done. So, for example, in the exploration phase, obviously the authority receives, for example, money for the applications. There has to be fees to pay, but those fees are covered for administrative purposes. And also, for example, there are trainings that the contractors have to pay, trainings for the developing countries, etc. There's a lot of obligation that has to be covered with those applications, but that money itself is not distributed as it is foreseen for the exploitation phase and that part of the sharing monetary phase. So how it's going to operate very, very, very quickly. So as I said, it's not very clear how it's going to be done. It has to be decided. The UNCLOS and 1994 gave us little guidance. The first thing is that the revenues have to cover the authority costs. So member states at some point will not have to finance the authority, which is happening now. So that will be the first. Second, there's a part that will cover, and this is very important for what Professor was saying recently, that a part of the funds will be allocated to the Economic Assistance Fund that is established in UNCLOS in Article 151. Number 10 and Section 7 of the Annex. And the purpose of the fund is assist developing countries which will suffer severe effects on their export earnings or economies resulting from the reduction of the price on an affected mineral or in the volume of export of the mineral to extent that such reduction is caused by the activities in the area. So in cases where particular countries will be affected by the competency of the minerals that are extracted by the area, this fund is going to be provided, is sought to help them. The way in which will be distributed is also need to be allocated and thought by the Economic Planning Commission that is not yet established. And third, thirdly, what the rest of that, it has to be distributed in an equitable way, as Article 140 says. And then we have little guidance of what this means, because we need to know what is equitable, what means a lot of all the elements that Article 140 includes, and also Article 160, for example, what it means developing country, what are the stakes. So this is being studied and proposed by the Finance Committee at this moment, and there's several alternatives. One alternatives are, for example, based on financial distribution, like very and based on calculation, based on when you need to calculate the per capita and the volume of the economy is, and make several different calculations. There's 3 models for that. Another one is, for example, also could be, for example, qualitative distribution. So what is the revenues that are received by the authority will be share with the international community, but in a way that is in a quality form for the humanity. For example, knowledge, competence, physical improvements, restoration for the environment, damages, or whatever. It's a different way to take back those resources. And also another way, that third way that is being discussed, is to have a Seabed sustainable fund. It is also one of the proposals, but entering into the detail, of course, is very complicated. But most likely one is going to be one of those monetary returns. There's 3 formulas for that, and those are the ones that are being discussed in the Finance Committee and has to be approved by the Council and the Assembly. And there are calculations that are made based on numbers on the money that the country has, the contributions, what will be the royalties that will be gaining by the authority, etc., etc., etc. And another question that is on there regarding non-monetary benefits, and whether it's the same with the marine environment, the protection of the marine environment, what I was referring to, if it is the same. It is the same in the sense that whenever you have already a regulatory framework that protects the environment, that is already something that is a benefit for the humankind. So that is considered already a non-monetary benefit. So any kind of regulation for an activity that protects the environment is already a benefit for the humankind. That's the idea. So all that could be considered non-beneficiary benefits. So
Right.
that's the idea of including in the list.
Okay. All right. Thank you very much, Ms. Derny. Now next, Ms. Gwenel Gurun.
Yes, thank you very much, Professor, and thank you very much for the very interesting questions indeed that I can read and that I can hear. If I may, I would just like to refer to what Ambassador Tuggio has shared with us about the momentum. And this relates to the question also of when the regulations will be adopted. And since we have lawyers in the room, if I may, I will refer to the agreement and one of the provisions which has been actually triggered by a member state, by Nauru in 21. And according to that provision, I mean section 1, paragraph 15 of the annex to the 94 agreement, then when such a mechanism is triggered, to explain briefly, then the Council is under an obligation to complete the adoption of the regulations within 2 years. So this was triggered in July 21. As you can calculate, those 2 years have passed. So what happened? The Council, in parallel to the negotiations of the regulations, has dealt with that question of what to do if there is no regulation adopted in 2023. And the last state of that, and that's why Ambassador Tuggio is so right in referring to the momentum. There is such a momentum, a pressing momentum, if I could even use that expression in English. And this is reflected in the decision of the Council adopted in July 23. Under that decision, for those of you who are interested, it's a decision contained in the document ISBA/28/C/24 that you can find on the website per sessions. You go to the 28th session to cancel, and then you will see that decision, very important one, that the one which includes the roadmap. And why is there such a roadmap? It's because the Council has decided to continue as a matter of priority the elaboration of the regulations, I quote, with a view to their adoption during the 30th session of the authority, which is next year. And the decisions add that at the end of its July 2024 meeting, so the upcoming meeting of the Council decides to assess, in the event that rules are not yet completed, the remaining work that will be needed prior to their adoption, and to consider eventually the next roadmap, which I referred to in the slides. So yes, there is pressure here on member states and members of council to finalize the elaboration of the regulations because of the provision which I referred to earlier, which has been triggered by, sorry, by no rule. If I may, Professor, there is another question relating to the oversight functions. And how does the ISA ensure that activities are conducted in compliance with the legal framework, sorry, and the terms of the contract? This is also a very interesting question at the core of the system. As my colleagues have mentioned, there is no activity which can be conducted without a contract. Contractors have obligations, several obligations. One of them is to report on their activities every year by the 31st of March each year. And those annual reports, which describe what they have done per the term of their program of activities in their contracts, is assessed by the Legal and Technical Commission. If the Commission finds that the contractor has not complied with its contract, the Commission eventually will report non-compliance cases to the Council, because the Council is a political organ with powers to issue penalties in case of non-compliance. This has never occurred yet, but that can go to very serious penalties. I don't remember, there was, I think, another very important question, but I don't remember the exact terms, sorry, Professor, about how at the stage of exploration, participation of developing member state of the authority is assured by the legal regime for the common heritage of mankind. And Talatu, you have mentioned the parallel system. So to take that as an example, because the enterprise is not yet functioning independently of the Secretariat. As you say, this enterprise will conduct activities for joint venture, but we are not there yet. So at the stage of exploration, under the parallel system you have mentioned, there are reserve sites which are exclusively for
Gwen, I think she have a disconnection. Maybe I would give the screen to Mr. Jose, if you have any comments.
Yes, I have one, because it was mentioned the idea of leveling the playing field, and in terms of environmental impact assessments, we are just going to have now, I think, quite interesting workshop in this training center for Africa that we opened in Egypt recently. And so I hope we can replicate that that training if needed in other countries. So it's something we always try to to have in mind. It's a very expensive science, the deep sea science. It's going very deep, like 5,000 meters. So I would really encourage all developing countries to benefit from the training opportunities that we do offer with contractors. Thank you.
All right. Thank you very much. While we're waiting for Ms. Gwen to join, I would like to read one question, and we'll invite two other from live question. The first question on the chat box is coming from Miss Davina Octivana. She asked about what is the difference between ISA's pillar in protecting the environment and ISA's pillar in sharing non-monetary resources for environmental protection. Do these pillars have the same meaning and implementation? This goes to Ms. Derny. And I would like to here invite to ask directly our own or renowned one of the few expert in law of the sea from Indonesia, Professor Eti Agus. Would you like to ask the question directly, Professor Agus? Prof. Eti, can you unmute? Or admin, can you?
Yeah, unmute, yeah.
Okay. Yes.
Okay, thank you, Ari. You know, my question is actually a little bit simple because I'm a teacher, you know.
Admin connection. Prof. Eti?
Is there any different rule seabed of man have impact on between the exploration and the exact seabed mining? That is a simple question that I would like to ask all the presenters. Thank you.
Okay. All right. I'm sorry, Professor Eti, your connection is not so good. So the question is the same as your right on the chat box, right? Because your connection is not good.
I don't know. You know, the connection was not so good. So
okay. Yes.
I don't know
so,
what do you expect.
Yes. Okay. I'm assuming that you're posing the question the same as you wrote in the chat box. So how common heritage of mankind have any rules regarding the contract? And secondly, is there any difference of or rules regarding the exploration and seabed mining?
Right.
Okay.
Right. Correct.
Yes.
Yeah.
Okay. And the second question, I would like to invite Cristo Emmanuel from the Center for Sustainable Ocean Policy, Faculty of Law, Universitas Indonesia. Cristo?
Yami.
Audible?
Yes.
Am I? Thank you very much for this opportunity. I have one question. So, we discussed recently about the phenomenon of sustainable. My question is, we recently discussed about the exploitation and exploration activities. My question is, what is the differences between the exploration or exploitation activities conducted by the enterprise of the ISA or by the companies under working contract with a country? Thank you very much.
Okay. Thank you very much. Maybe I can invite another question just for one last round question. I know there's so many burning questions. Mega Wulandari, are you there?
Hello, Bang.
Yes.
Am I audible?
Yes.
Okay. Thank you, Bang Ari, and thank you for all the speakers. This is so amazing presentation in the Faculty of University of Indonesia. I have a curiosity in 2 points, which is, sorry. Okay. So I want to ask about how does the ISA balance states' interest between conservation and sustainable use, between the environment and development economic benefits, and is there any disputes related on equitable sharing from the economic benefits for the state's members? And the second question from me is, how long does the contract valid between the sponsoring countries and the enterprise for doing activities exploration and exploitation? Thank you.
Okay, thank you very much, Mega Wulandari. And since this is the last round of question, my apologies for the rest of the participants who asked questions. And I would like to ask another 10 minutes for the presenters to answer or comments on the questions. Ms. Akindolore or Ms. Derny?
Okay, regarding the first question that you recall about the difference between the pillar on environment and the sharing monetary, I think I addressed that and then the previous one, and I will take the opportunity also to respond that question on the contractors, the prerequisites or qualifications for the companies, if any company can apply for a contract of exploration. Actually, the regulations that are in place for exploration activities are very specific on the requirements that the contractors has to comply to applying for a contract of exploration. Apart from the certificate of sponsorship that has to come with the application, they have to accompany no certificate, but to demonstrate that they have financial and technical capabilities to undertake the exploration activities. So they have to demonstrate with documents and statements that they can actually afford to undertake these activities with, well, statement and financial plans and financial statement and certificates, accountants, and a lot of documents that needs to be present in the application. So in general, also they have to explain and have to show that they have experience, knowledge, technical skills, and experience to do the proposed plan of exploration, the key equipment and methods that they're going to use, and the exploration, the technology that they plan to use, and they are accessible, and the information about the characteristic of the technology, and also the financial and technical capacity, not only for the conduct the activities of exploration, but also to respond for any incident or activity which can cause a serious harm to marine environment. So the requisites are quite exigent and restrained, and also they need to accompany this with a lot of evidence and supporting documents. So yes, there is requirement. Not any company could apply for this, and all these aspects are assessed by the Legal and Technical Commission. So they need to comply with several requirements. That's for now. I will leave it to Juan and, well, my colleagues.
Yes. Or Ms. Akindolore, do you have something to add?
I did, yes. Thank you so much. Yes, I did have some answers to some of the questions. I think Professor Etty had asked a very simple question that I think is quite important. So the first was about the difference between exploitation, mining and exploration. Now, the different activities that happen in the area can be grouped into three. And I will post the meanings from the exploration regulations in the chat so that people can see the different stages. The first stage is prospecting. Now, prospecting means there's no proprietary right? You're just going to the area to get an idea of the economic value without any exclusive right to do anything. in the area. That's the first stage. For this, you don't need a contract as an entity. You just need to give due notification to the Secretariat that you intend to carry out prospecting in the area. Now, the second stage, which is what we've been doing as a Secretariat for the last 30 years, is exploration. And I've posted the meaning of exploration in the chat. And that means to search for deposits of polymetallic nodules, sulfides, crust, as the case may be. This is just from the nodules regulation, so it refers to nodules alone. To analyze the deposits and to just, it's like a stage of research, as it were. There's no extraction for commercial use in the stage of exploration, and that's the stage that the ISA is in now. Exploitation has not yet happened, and exploitation will not really happen yet until we reach that stage of progressing the regulations or triggering it, as Gwen had explained, under the 1994 agreement. And then that's the next stage now, which is exploitation. And exploitation means the actual recovery for commercial purposes. So remember the mineral resources that I showed in the beginning of my slides, the rocks and the chimney, and then the cobalt bulk. That's when you're extracting those from the area for the purpose of commercialization, turning them into minerals, actually. That is the next stage, and that is the money-making stage that Mariana had been describing in her last intervention, about how those resources can, be shared for the common good. And also touching back to the question that Professor Etty had raised as to what exactly is the common heritage of mankind. What does that mean? So in summary, it means that whatever minerals are extracted from the area, from the exploitation stage, should benefit the whole of humanity, because those minerals were not found in the jurisdiction of any state. They belong to the jurisdiction of every state. And so the benefits from those minerals should be felt by the world in general, and not just one state. So I hope that is a very simplistic explanation of the several activities that happen in the area and the common heritage of mankind. Very quickly, I want to respond to Crystal. Crystal had asked about the difference in exploration and exploitation. I hope that my explanation just now helped. But he also asked that the activities being conducted by the enterprise, by companies under working contracts. So this is something I also want to clarify. I think there's a little bit of a misunderstanding here. Now, the enterprise has not, like Gwen said, the enterprise has not started activities yet. It's established currently within the Secretariat. It hasn't started activities through joint ventures. So that is not yet happening. So there are currently no contracts through the enterprise. The contracts that exist now, 30 active contracts in the Secretariat, they are not connected to the activities of the enterprise. They are contracts by sponsoring states of either individual companies or countries or governments' own entities. So I hope that was helpful. There was one more question from Mega, but I didn't quite hear it because it kept going in and out, but I've asked her to send me a message, and maybe I can respond to her directly if we don't have any more time. Thank you so much.
Thank you very much, Ms. Akandilore. Gwen, it's good to have you back. Do you have any maybe last answer or comments from you from all of the questions? Yes.
I apologize for shutting down. My battery was the issue, and then I was finding my cable. So very sorry for that, for having missing the very interesting discussion we had. And maybe my colleagues apologize too, because maybe you have already covered that part of the sentence which dropped in the middle of where I was trying to explain how actually, even if the enterprise is not functioning independently of the Secretariat yet, participation of developing states is guaranteed by precisely the common heritage of mankind regime, which we have talked about, by the fact that in areas which are called reserved areas, only entities from developing states or developing states can apply for exploration rights in those reserved areas. Those reserved areas are contributed by contractors when they apply for exploration rights and they are not from developing states. They are not either developing states themselves or entities sponsored by developing states. So as Ambassador Tujo mentioned, this is a very costly exercise. So the system, before the enterprise starts to function, is to enable the participation of developing states by reserving to them the exclusivity of applying for exploration rights in reserved areas which have been already explored and assessed for having the same potential commercial commercial potential than the sites which have been issued to contractors from developed states. So this is through the parallel system that participation of developing states is possible right now before the enterprise starts to explore and exploit through joint venture arrangements.
Okay, thank you very much, Ms. Gwen. And last, Mr. Jose Dallo.
No, yes. I think my colleagues addressed the questions fully. It's always good to have lawyers in your team because they know all the solutions to those tricky questions. Just to say that we again, I think I mentioned that before, and some of the questions were related to how we ensure developing countries benefit. I think that's there's a different elements. For example, one mentioned the reserve areas. They have the activities that I was mentioning too, and so more than happy to follow up the discussion of this webinar in case someone is interested to find out more about these opportunities.
Okay. Thank you very much, Mr. Jose Dallo. And that's because of the time limitation, and I know you're very late at your time there. And now here in Indonesia, we're just starting our day. But nevertheless, thank you so much for giving us your insights, your information, and your knowledge, sharing to us, the academician, to the students, and also to the practitioners. And for that, I would, on behalf of the Faculty of Law in Indonesia and also the Indonesian Society of International Lecturers, thank you so much for participation. And now, for the closing remarks, I would like to invite the Secretary of the Directorate General of Legal Affairs and International Treaties, also the Deputy Chief Missions to the of Indonesia and Republic of Indonesia to the United Kingdom, Ms. Sahadatun Donatirin. Ms. Donna, the screen is yours. Admin, would you like to unmute the microphone? The host, admin?
Sudah, Pak. Sudah aku host juga.
No, please unmute. Unmute. The host, unmute. Can you unmute yourself? Yeah,
Yes.
Yeah. Okay.
Yes, now yes. I think they don't want to finish the session because it's too interesting for us to terminate in 2 hours. But again, because time is, as Ari said, it's not allow us to stay awake. It's not a work life balance style of approach. So I again thank you so much. I as a Indonesian permanent representative in New York, Faculty of Law of the University of Indonesia. Well, and well, of course, the Indonesian Society of International Law lectures for having this event done. Especially big thanks to Ambassador Hari Prabowo and Ambassador Adam Tugio for their participation on this event. Thank you, of course, Talatu, Jose, Mariana, and Gwen for staying too early, too late, and overcome all the time differences for us, Indonesian colleagues, to have your deep knowledge on this issue. We're hoping that this collaboration will become regular, of course, because Indonesia have a special ties with ISA from the time of its establishment by having Pak Hasim Jalal at that time as the first president of the Assembly of the ISA. The role of ISA as custodian of the deep sea minerals is important, of course, and it's a common heritage of mankind. So it is the interest of all mankind to support the work of your organization. To carry out this mandate, the ISA upholds the principle and norms regulated under the UNCLOS and the 1994 agreement. Well, during the session, we see that the latest development has shown that deep sea mining is no longer a theoretical discussion, but it will be a reality currently and in the coming years. I encourage, please, for all the participants as well as the viewers on YouTube to continue pursue their interest in studying further on the deep sea mining. I again thank you very much for all who supported this virtual lecture, as well as the participation for their active participation. Thank you once again, IS. Thank you, Pak Ari. Back to you.
Thank you so much, Miss Donna, for your closing remarks. And that's the end of our virtual lectures of today. Again, thank you so much for participants, and I'm sorry for not accommodating all of your questions. And I'm sure this will be one of the events that we are going to come across again in the near future. Thank you very much once again, and I hope all of you have a great day, have a great rest, yeah. And again, maybe we can meet again in the near future. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so
Bye-bye.
much.
Take care.
Salam.